Good afternoon. I'm very happy to see all of you here this afternoon. I'm Nancy Davenport, and I'm the interim university librarian here at American University. And it's my pleasure to start off this presentation today and to introduce our speakers to you. So for today's presentation, our two keynote speakers are from this university. And then we are inviting a colleague from the Association of Research Libraries to begin and to lead our discussions afterwards. Our first speaker will be Patricia Aufderheide. And Pat is a university professor in the School of Communications. She's the founder and co-director of the Center for Social Media here at the university. She is received her PhD in history from the University of Minnesota. There's more to her bio, but I'll tell you that in a second. Peter Yazzie is a professor of law at American University's Washington College of Law, teaching domestic and international copyright, supervising students in the Glushko-Samuelson Intellectual Property Clinic. And Peter is a trustee of the Copyright Society of the United States of America and a member of the editorial board of its journal. Since 2005, Peter has been working with Patricia in the Center for Social Media on projects designed to promote the understanding of fair use by documentary filmmakers and other use communities, including research libraries. Their book, Reclaiming Fair Use, was published this year. Professor Yazzie received his AB from Harvard and his JD from Harvard Law School. Then joining us later for the discussion will be Brandon Butler, who's the Director of Public Policy Initiatives at the Association for Research Libraries. That's a group of 126 research universities and libraries from North America. His responsibilities there include analysis and advocacy regarding copyright, privacy, surveillance, free expression, and telecommunications. And when I started my library career, we would not have had to use that word surveillance. He also writes the ARL policy blog, policynotes.arl.org, and is the owner of the policy Twitter account at ARL. Before coming to ARL, he was an associate in the media and information technologies practice of the law firm Dowlowes PLLC here in Washington, D.C. We invite you all to stay, to listen, to take notes, to engage, to challenge, and then to stay and talk informally with us during the reception afterwards. Patricia?
One of these must be on, right? Well, maybe there's just a trick I don't understand. Okay? Okay. So, I'm really excited to be here, and thank you for coming. I see a number of friendly faces, and I'm really thrilled that I see some that I don't know, and I would love to get to meet you during the reception. It's really been an extremely exciting journey. For me, somebody who's trained in communication and who spends a lot of time with documentary filmmakers and film, to get involved in the world of IP policy and see its direct connection to expression, to censorship, and to the ability to change the law through practice, which is what we've been involved in. I want to kick this off with a little video. How many people here have seen the remix video called Buffy v. Edward? Oh, go you. You are one of the 4 million. Yes, 4 million people have seen a remix video done by Jonathan McIntosh, a genius up in New York, who remixed many old Buffy the Vampire Killer episodes. I'm sure, how many people here have watched Buffy? Thank you, I love you all, me too. I saw an episode this weekend. And Twilight. And the juxtaposition between those two is a juxtaposition between a feminist heroine, Joss Whedon, yes, feminist heroine of the 1980s, and a hero of a film that features feminine masochism in the 2000s, Twilight. Thank you. So this is the latest version, which features commentary, his own commentary on his own remix throughout. And I'm sure somebody's going to get audio.
Not late, but the bell rings. Uh-oh.
Sex. The sex drive in the human animal is intense.
Hello,
Of course, for teenagers such as yourself,
I'm Edward Cullen.
overwhelming, with all sorts of hormones surging through your bodies, compelling you to action. Among teens, pregnancy is the #1 negative consequence of sexual activity.
So, spill. What was that all about?
Nothing serious, I think.
It looked like more than that to me. He got all googly-eyed.
Survey says vampire.
I'm sorry, I'm just trying to figure you out. You're very difficult for me.
I'm the Slayer. Slayer. Chosen one. Look it up.
No, I'm on a special diet.
What are you doing? Here, at this table, talking to me like we're some kind of talking buddies?
I feel very protective of you. Don't leave.
Hello?
And you and I are gonna go somewhere.
What?
Alone.
No.
I'll do whatever it takes. I don't have the strength to stay away from you anymore.
Well, he actually told you. He said, I love you.
Well, I didn't let him get that far.
Buffy, I'm really worried. These things can become pretty twisted.
Hi. Well, nobody's
Stop trying to see me. And stop calling me.
Wait a minute.
You know, being stalked isn't really a big turn-on for girls. Get out.
I like watching you sleep. It's kind of
Get out
fascinating.
or I will drop you out head first.
Well, I just want to try one thing.
It's you. You're sent.
Did I ever tell you the whole smelling people thing's a little gross?
It's like a drug to me. Like my own personal brand of heroin.
Oh my God, are you 12?
I've killed people before.
And you're sure this isn't just some fanboy thing? Because I fought more than a couple pimply, overweight vamps that call themselves Lestat.
I wanted to kill you. I've never wanted a human's blood so much in my life. Are you afraid?
No. You know what I feel? Bored.
Seek you out, flay you alive. One more word and you won't survive. And I'm not scared of your stolen power. See right through you anyhow.
So I wanted to show you guys that video for a couple of reasons. One thing is that it shows you, and I guess we could get lights back on in the event anybody wanted to take notes, but probably better for down if you're using a tablet, right? Okay, who wants lights up? And who wants lights down? Okay, guess what? Nobody much cares. Turn the lights on, but more people want lights than not. Okay, so I wanted you to see that because, first of all, I think the remix itself, the original remix, Buffy v. Edward, with 4 million viewers, demonstrates the importance and to some extent the common practice of remix these days. Many more people are consumers of remix than are making remix, but increasingly as these tools become easier, you're going to see people remixing everything. Jonathan McIntosh happens to be a really highly trained editor. And so his work has a quality that most people's doesn't. But can I just recommend one more Jonathan McIntosh? Too Many Dicks on the Dance Floor. Turned into Too Many Dicks on the Daily Show. It's really good. And he uses more than 100 episodes of the Daily Show to make this 5-minute video showing that there aren't enough women on the Daily Show, mixed to a pop song called Too Many Dicks on the Dance Floor. I'm using a very high quality example, but you and your students can think of many other examples of remix in daily life. Long before we had the capacity to do this in audio and video, of course, we were doing it every day in text, and particularly in academic scholarship. This is most of what we do as academic scholars, is we do some kind of recombination in order to create new knowledge. That's what all the footnotes are about. So this is very common. The new thing that he did here is used with a software tool called Popcorn, which allows you to annotate in video. And this is exciting to me, not only because of what he was able to do with it, but because this is a fabulous new scholarly tool. It allows you to do a kind of direct annotation and commentary that you could have never done before in this medium. So these are two ways I'm arguing that fair use is coming very prominently into our lives. Of course, it's also in our lives every day as librarians, as teachers, as scholars, as students, in all the rest of the work we do. Every time we put something on e-reserves, or every time we use a clip in a classroom, every time we quote from another source. These are all examples of fair use. And so what I hope for today is that by the time you walk out, you will have both some answers and some new questions to pursue the answers to. But in the spirit of that, before I turn this over to my colleagues, both of whom are lawyers and really know what they're talking about, I would like to just find out from you if you have burning questions and issues that you came with so that we can make sure in our presentations that we work them in. So I know Wendy has a question.
The nonprofit organization has denied me copyright permission to reprint a public service ad in an upcoming book. I have identified a university library archive that has the image. If I were to use the image from the university library, will I be exposing that library to legal risk, myself, my publisher, etc.?
Why, I have people who can answer that question for you. I'm sure we'll be working it into the presentation. Okay, who else? Yes.
One thing I noticed a lot in the news are these. Oh.
Anybody doesn't know who
That really builds it up in a way that's unfair. I'm Robin Chinromer. I'm the communication librarian here at American University. And I was really excited about this event today, so I started looking in the news for some incidents where fair use and copyright have come up with video in an interesting way. And there's a case with some cities that are looking to promote themselves. I think it was Minnesota, and created a video where they used the lyrics to Carly Rae Jepsen's one of her songs, and did it where people around the city were singing this song. They put it up on YouTube, everybody loved it, and then they had a takedown notice from YouTube and had to pull it even though they're trying to get it up again. So I see a lot with YouTube specifically, and what happens when suddenly YouTube takes down your work. What's going on with that, and any advice about repercussions and actions?
Oh yeah, the YouTube takedown, and when you or the content ID match, right? In which there's actually a little drop-down menu in which you can select fair use is the reason why it's okay to put it back up. But is it what's going to happen to you if you click it? How much trouble will you get into? Okay, great question. Who else? I know. Come on, people. You showed up here. It's 3 o'clock in the afternoon. Come on. There must be some reason.
Hello. Hi, my name is Noble. I'm a music librarian at AU. This happened yesterday, actually. I got a call from scholars from other institutions, and he's doing research on the specific composers, and we happen to have a historical sheet music in the historical sheet music collection, which is post 1923, so it's still copyrighted, and he wants to have entire things actually digitized and send it to him. And I know once it's digitized, I can send the material itself through ILL, but it's too fragile. But he wants to have entire thing, so it's only 4 or 5 pages. But if I digitize it, and I know that will different law applies, so I wasn't sure if that's will be under fair use or not.
Great, and I think we're going to be able to get to that too. Is that a yes, Brandon? Okay, but if we don't answer your question in the presentations, we are going to answer them afterwards. Yes.
Camilla, University Communications. So we get a lot of press coverage for our professors, and we'd like to highlight that on our website, and we'd like to use media organizations' logos to show how we're using, basically to highlight the stories. So how can we use those logos on our website?
Okay, and
yes, hello, I'm Adele Schmidt, and I'm an adjunct professor at the School of Communication. I'm teaching film and video production, and a lot of other courses in documentary filmmaking, fiction, etc. And I have the students always come, they have archival footage, archival photos, they have music they want to use in their films. And I'm always very cautious, and I would like to be less cautious and maybe get some advice.
By the way, you have something did you get a packet when you came in? Okay, you got something in your packet that's going to make your life a whole lot easier. The Doc Filmmakers Statement of Best Practices and Fair Use. Okay.
Thank you. My name is Esther Dell. I'm from the Penn State College of Medicine Library, and one of the new things that I've been asked to do most recently is to support systematic reviews. And one of the things that that I've been asked recently is whether I can help create a database of articles, which is sort of covered by one of the best practices for the scientists to review articles so that they can come up with their analysis. But one of the things that we're looking at in one project is it's a multinational group. So I don't know if that throws a kink into the problem. If we create a database of articles for them to review, and they're scientists from other countries.
Okey-doke.
Scott Talon, colleague of Patricia's and others in SOC. I like to use old school media sometimes, like news articles, and to make even these things called packets. And when I did that, the bookstore said, oh, you have to get permissions from all these news organizations before we'll ever copy this. And I understand why they're saying this. I'm wondering how true is that, and what are the avenues around that?
Oh, I think there's a bunch of librarians here who really, really want to help you. Okay, and is that overlapping with some other people's concerns? And we got two more, and then we'll move on.
I'm Thomas Meal. I'm the CAS web guy. One simple question is about stuff like that. My understanding was that that's obviously fair use, but the NAB and organizations like that could still sue you, and so you'd have to defend yourself in court. And so even though it was fair use, it wasn't worth doing because you'd still have to hire a lawyer and the legal fees. But that was like 5 years ago. But so now we got to the point that the NAB, et cetera, have accepted this type of stuff and they won't harass you. And then a simpler question is just regard to professors' own works that are on scholarly services like Elsevier and all that, and if they want to post PDFs or something like that of their own articles or your own articles, some guidelines about that would be useful. Thanks.
Oh yes. Okay. I think we got a couple of pieces of good news here that we're going to be able to weave in. Maybe some cautions. Okay. Announce yourself.
Hi, I'm Jennifer Hodgson with two of my colleagues here from the U.S. Department of State, and we work on a distance learning program, and we're trying to get more clarity onto what types of copyrighted material we can use in our classes. Online classes.
Great. And I think you got some colleagues here who also would love to know the answer to that, because I think we're all working in at least a hybrid environment and often online. Okay, unless somebody else has one more burning question, I think I'm going to turn this over to, yes, okay, one more burning question.
Hi, I emailed you this summer, and I'm Nadia Trower with the University Publications, and we're redesigning the American magazine, and potentially we'll need to grab images to comment on for commentary for interviews with alumni. This past article that we did was the top 10 fictional cop characters, and we had to go through and get all the photos online, but we couldn't necessarily get to all of the actual copyright owners to get proper citation, etc. So, like, I guess guidelines to follow in finding images and crediting them properly, and if you're not able to, what you should do to move forward.
Great. Okay. So I think if it may not be totally clear to me how to get to the PowerPoint. Oh, wait a second. Yes, it is. Okay. So I'm turning this over now to my colleague Peter Yassi.
Thank you. So let's see. Mike is here. So what do I do?
You should be able to speak from here.
Well, I would have, but I see this better from here.
No, I know. You should be able to speak from there and be.
Okay,
Are you picking
let's
up?
give it a try. Do I sound okay? Good. So the goal here is to very, very briefly do a little bit of background that is going to inform all the more specific conversations that we have going forward about the best practices work that Pat and I have been doing, and in particular about the work that the three of us have recently done on copyright in the research and academic library setting. And I think the place to start, even though it may be self-evident to all of you, is at the beginning with the question of
The film is asking to use that. Sorry.
at the beginning with the question of why this scheme of law, this limited monopoly in imaginative and creative works exists at all? And the answer turns out to be pretty easy to find, because we can look right to the founding documents of the U.S. copyright system, the most important of which is the Constitution, Article 1, Section 8, Clause 8. It makes this point perfectly clear that copyright exists not to make anybody rich, not to reward any deserving person, not to support or preserve any incumbent business model, but in order to promote making and sharing of culture. And it's very simple, and ever since everyone who has had occasion to ask or answer the question, why is copyright, has given a consistent answer. Most importantly, again and again and again and again over time, the Supreme Court of the United States, which has the last word in all of this stuff since copyright is a part of the federal system, has reiterated that proposition. So how does this work? How does copyright help with culture making and culture sharing? And the answer is in two ways, which are in tension with one another. One is the idea of giving creators this limited copyright monopoly. The concept, it's unproven. We've been doing this for a few hundred years. We still don't have any statistical evidence to back this up. But the concept, probably too well established to contest at this point, is that giving creators rights makes them more likely to make culture. If you didn't give them money, they might spend their energies trading pork belly futures, but because you give them money, they write books. Again, it's a little dubious as a social science proposition, but it's very deeply embedded. So we believe in that, even if we can't prove it. We believe that incentives, limited incentives, appropriate incentives, are important. But the other thing we believe in is that this structure of copyright law also encourages the making of new culture by specifically creating space for creativity that will permit new makers to use existing cultural materials. And that's accomplished in our copyright law through a variety of devices. Devices that are designed in their totality to create a kind of balance between the proprietary interests of those who make culture and those who buy and collect and amass culture that has been made by others on the one hand, and the public, which has an interest in access to culture, which includes all of the present and future culture makers on the other hand. So how do we get this balance? Well, we get it through a variety of devices, including the one that we're talking about today, primarily fair use. But before we talk more about the tool, we should ask again, why the balance? Why is this so important? And again, as the slide indicates, I think there are two reasons. One is that we all know, especially those of us who are actually in the hands-on culture-making business, that nothing comes from nowhere, that all new cultural production builds on existing production. So we have to be careful, because if we overprotect existing culture, we're going to end up inhibiting, chilling new creativity. And then, of course, the other reason, which is a more technical reason, and one that resonates more probably with some of us in the academy than others, we people in law schools think about it, and I know people in communications think about it, and I know librarians think about it, and that is the First Amendment. We have a series of authoritative decisions from, among other places, once again, the United States Supreme Court, which say copyright balance is important to make this whole scheme of federal law work, because we have in this scheme of law two things that are a little bit in conflict with one another. On the one hand, we've got copyright, which is all about telling people that in many situations they can't speak or will be penalized for speaking. And then we've got the First Amendment, which says you can speak. So how do you harmonize those two conflicting constitutional commands or principles? Well, through devices like fair use, which say, in effect, that sometimes speech that involves the repetition or quotation or appropriation of pre-existing legally protected culture is nevertheless non-infringing and legitimate. When? Well, when it's a fair use. And that drives us back to the question that has fascinated, beguiled, and frustrated us since 1841, when the fair use doctrine was first imagined by Justice Joseph Story, and that is to say, how can we tell if something is or isn't a fair use? Now, when I started doing copyright law longer ago than I would like necessarily to admit today, but you know, it's got to be, it's upward of 40 years. We didn't worry about this stuff so much, and as a result, fair use wasn't such a big deal. Copyright just wasn't as scary then as it is now. Not to lawyers. Lawyers aren't scared of copyright in particular, but to their clients and to others who are unfortunate enough not to have lawyers at all. Why has it gotten scary? Well, one thing is that it's gotten longer. It used to be that copyrights ended. Some of them, indeed, statistically speaking, most of them ended after 28 years. Some went on as long as 56 years. And now we've got copyrights thanks to a series of copyright extension legislation that go on seemingly forever, not literally, but it could almost be well on into our new millennium. So it never seems to end, and that means we worry about it more. Another thing that happened in 1978 is really quite important, and it's especially important for libraries and for those who love them, and that is that suddenly copyright became the default form of intellectual property for all kinds of written content. That hadn't been the case before, but it is now. Not just written content, but any content that is expressed in some kind of stable record. Used to be that copyright was the default mode of protection for things that had been published, which was a big enough universe of content, but a relatively small one compared to the total universe of things, both published and unpublished, which is the scope of coverage of copyright today. So that's got to make us worried. It's got to make us worried because, in effect, we've got to assume that anything, or at least anything that wasn't published before 1923, is copyrighted. We can't make any other default assumption. Thus, the question of what the exceptions to copyright may consist of becomes ever more important. Then there are these penalties. More and more, we hear about the bad things that can happen to people who get on the wrong side of copyright law. Some of that is just puffery, the sort of the PR, in effect, of copyright owners, but some of it is real. It is true that these days, if you are found to have infringed copyright in a work that has been registered in a timely and appropriate way, of course many things, especially unpublished things, haven't been registered in that way, but we'll make the assumption that it has, you could theoretically end up owing a lot of money, even if no one could prove that you gained or that they lost as a result of your infringing transaction. I say theoretically because in practice it doesn't happen. In practice, these provisions apply and were designed to apply and are actually applied to people who are doing sort of commercial scale piracy of commercial content. But if we read the book, it says it could be up to $150,000, and that gets your attention. It gets your attention even more because big content holders, not necessarily creators, but again, organizations that buy up and amass and commodify creative material like record companies or movie studios, have been very aggressive in the last decade about enforcing their rights against ordinary people, kind of like, not actually quite like, but kind of like us. And of course, all of that aggressive enforcement, most of which, although not all of which is a thing of the past, was in a very specific context, and it was in the context of file sharing and to a slightly lesser extent BitTorrent distribution in the motion picture industry.
Well, you read about some grandmother getting sued or some 13-year-old getting sued, and you get worried. And the fact that they are in a different position, doing a different thing from where you are or what you're doing, even though you can tell yourself that at a rational level, doesn't exactly reduce the fear. What could reduce the fear? Well, that's where we are here. Oh, okay, logos of companies that are not nice about copyright. Actually, Discovery isn't bad. They're kind of a sweet company in some ways. More logos. You get the idea. So, well, one thing we can do is listen to what others tell us. And that's what we've been doing for a while about fair use. We've been listening to corporations that tell us things that are in their interest to tell us rather than things that accurately represent the state of the law. We've been listening to experts, some of whom, and I really do mean some because this doesn't apply to all, but some of whom have made a business out of making copyright scary so that people will depend on them to come and explain it. Experts whose approach to giving advice on copyright promotes dependency rather than independence. And then, unfortunately, worst of all perhaps, we also have been listening to or reading about what is and isn't permissible, what doesn't constitute fair use in a variety of so-called guidelines documents, all of which are suspect. Some are completely bogus. In other words, there are lots of rules of thumb, 2 paragraphs of this, or 5 notes of this, or 1 page of the other thing, or a minute and a half of the thing again, none of which have any basis in law. I mean, we could talk endlessly about where that stuff comes from. It comes from all the places where urban folklore comes from. It's sort of as an example of truthfulness, it's sort of on a par with the alligators in the sewer, and you can forget about it. The harder stuff to deal with are things that have a little bit more of a pedigree. So perhaps some of you know, I'm sure many of you know, that back in 1978 when this new Copyright Act, the one in which the fair use doctrine, which had been kicking around in the courts for a century and a half, was first codified, there was a decision taken to get together some publishers over here and some librarians and academics over there and come up with a set of fair use guidelines for classroom photocopying. And they duly did that. They locked people in a room and didn't let them out until they agreed to something. And of course, in the room, there were a lot more publishing lawyers than there were equivalent, sort of spokespeople for users of equivalent strength. And so the resulting document was both skewed and excessively restrictive from the get-go. In addition, it didn't represent by anything like the full extent of any of these communities. So it was a flawed document from the beginning in a variety of ways, and it's just gotten worse over time because that document was originally intended to describe a kind of a floor, you know. It was saying, well, here are some things that are certainly fair use, and there are a bunch of other things that you could do, and those might be fair use too. And the ink wasn't wet on that document before the publishers began to flip it in their public relations and represent it as a ceiling on fair use. So it's a terrible document, and it is the magic mountain that has twisted our understanding of copyright in the academic community askew, and it really ought to be jettisoned as a significant source of reference for the future, along with some cognate documents that were written at or about the same time. Our friend Kenny Cruz has a wonderful article in Ohio State Law Journal that details exactly how useless and suspect all of these guidelines are, and I think that's up on the CSM website if anyone wants to look at it. So, clearly that didn't work. What does? Well, one thing that turns out to work pretty well with fair use is actually going to the courts and asking the question in a variety of ways that courts can answer, that is through actual cases of controversy, and that is, what do you mean by this fair use stuff? For a while, the courts weren't that helpful either. They dithered and dawdled, and occasionally actually wrote opinions that were too restrictive in their implications. But all that's changed in the last 20 years. And what we're seeing now is an absolutely amazing, I don't know what to call it, an efflorescence, a golden age, a new flowering, pick your term, of fair use in the courts of the United States, probably as a reflex of all those factors that I was telling you a moment ago have made copyright so scary. Turns out judges love this stuff about balancing interests. That's what they do, after all the time in all their other judicial decision making. So why shouldn't they do it here? And they're aware that the Supreme Court has said, as I mentioned earlier, that the presence of fair use in the copyright law is a definite feature and not a bug, that if it weren't there, we'd have a kind of constitutional train crash on our hands. And as a result, in the last, well, I actually think it's more like 20 years, there's been a shift in this doctrine. And let me tell you a little bit about what's happened to the interpretation of fair use. Used to be that the only thing we had to go on, other than all these bogus guidelines, was the law, the statute, which was in effect a recapitulation of what the courts had been doing for the 150 years previous. And it asked us to ask it directed us to ask at least 4 questions in assessing whether a use was fair. Whether it was a court assessing it after the fact of use, or whether it was a potential user trying to guess before the fact whether or not they were getting into trouble. First, why? What are you doing this for? Second, what? What are you doing it to? What kind of work are you using? 3, how much? A lot, a little? The right amount or not? And 4th, okay, what's the economic harm? Not just any kind of economic harm, but the specific economic harm that results from some kind of substitution effect in the market for the protected work, the work that's being used without authorization. And that's great, but it's all kind of high level and a little hard to pin down, and it's got so many moving parts that it's difficult to know which of them matter and which of them don't matter. It's actually, in a way, more confusing, perhaps, than it is clarifying. I think judges understand that. I think judges understand that the first generation of post-1978 fair use case law that hewed very closely to these 4 factors was actually a pretty big disappointment in terms of the degree to which it served and enabled the fundamental purposes of copyright law. And so, starting in the late 1980s, everything began to change. And judges began to ask not those sort of unfocused 4 questions, but 2 questions. And often only 2 questions. First, is the use transformative? What does that mean? Well, we know from 20 years of case law a good deal about what it means. It means, do you add value to the material that you used? Do you repurpose the material used? Do you present it, for example, to a different audience than the audience for which it was initially intended? Do you employ it in a context that's dramatically different from the context in which it was designed to be employed? So, for example, in the instance that we heard earlier, I think, or heard and saw earlier, I think for fairly obvious reasons, the mashup is a very good example of a transformative use. The use, although I haven't seen these commercials, of existing soundtrack, existing music to create a soundtrack for a city commercial, maybe a little less so, since in a way what's being done with that music, that is getting people to dance around and move their mouths to it, is sort of just what that music, or one of the things that music was probably intended for in the first place. So I think in both that example and in the video we saw very good, not polar, but at least distinct examples of more and less transformative use. Let's assume for a moment that you've satisfied this. I should say one more thing about how to satisfy this criterion, this first of the 2 major criteria, and that is that it really, really helps to have a story. That's why I loved watching Jonathan McIntosh's video just now and watching the popcorn annotations, because he was telling you a story there about why he did what he did. And it was a very, very compelling story. And one of the things we find in examining the fair use case law is that users do a lot better when and if they're challenged, and of course usually they're never challenged at all, but in the odd, rare, extreme case in which a user has been challenged, then it helps a lot to have a story. And a good story, preferably a true story, that's always nice, and if possible a story that existed before the fact of the use rather than the one that was made up and retrofitted to the use in a desperate attempt to justify it after the fact. Stories count a lot. All right, so suppose you've got a good enough story, suppose you've convinced the court or the decision maker, because it wouldn't necessarily have to be a court. You could be making this pitch to your own lawyer or to a publisher just as easily as you could be making it to a pitch. Suppose you've convinced the decision maker, who we will assume is well informed about this stuff, not always true, but that's another matter, that your use is transformative. Well then, what else? Well, you have to show that you used about the right amount for the purpose. There's a very interesting and kind of to me very fascinating, fairly recent decision from the district court in New York from Judge Patterson in the Harry Potter Encyclopedia case that some of you may have followed. This was the case brought by Warner Brothers and J.K. Rowling against a small publishing company that was putting out a reference book on the Harry Potter novels, you know, character biographies and you know, items on different spells and whatever it may have been, mythical creatures and the like. And the judge thought this was terrific. The judge said this is not just a transformative use, this is a highly transformative use. When you take existing content and you make a reference book out of it, that is existing fictional content, and you make a reference book, that's a wonderful example of transformative use. So what went wrong? Why was the case lost rather than won? Well, it was because in the judge's view, and I think the judge was probably right, the gobs of material that the encyclopedist had taken were really out of proportion to his encyclopedic purpose. And so, not throughout, it is important to say, but enough instances so that the judge did, I think, probably couldn't feel comfortable about saying, yeah, we'll give this a pass. So something can be transformative, it can even be highly transformative, and it can still be on the losing end as a use in a fair use case if the rule of proportionality, as we might refer to it, isn't followed. Now, one more thing about the rule of proportionality. The question is not, did you use the least amount that you could use to accomplish your purpose? That would be a stupid question, because in that case we would get new work that was less good, less effective, less powerful, less communicative than would otherwise be the case. The question is not a question of necessity, but of appropriateness. Did you use the amount or an amount that was suitable to your purpose, which is a much, much more liberal test. I was interested that most of Jonathan McIntosh's popcorn bullets did not refer to his choices about the amount used, but only about the nature of the use. I suspect that one could do an overlaid set of bullets there which would explain very well why the amount was appropriate too. And if you were really mounting a full argument as to why that wonderful video was fair use, you'd need that too. So the work that Pat and I have been doing has three pillars, and into which we managed recently to inveigle Brandon, has three pillars. The first I referred to, copyright is for the common good, copyright is for the good of the culture. The second I've referred to again, the trend in thinking about and writing about copyright in judges' opinions and in other sources is to emphasize these questions about transformativeness and proportionality. Not that people don't talk about the four factors anymore, they do, but they have a vestigial rather than a central importance in judicial decision making these days. Here's the third pillar. Some wonderful scholars have done a lot of good work on fair use in historical terms in the last several years, and they all deserve enormous credit for aiding and abetting and promoting this fair use revival that I was talking about a moment ago. They are too many to name, but I want to name one of them, and that's Mike Madison at the University of Pittsburgh, who was perhaps the first, not the last, but the first copyright scholar to set himself the daunting task of reading all the fair use opinions decided from 1841 to what was then the present day in the mid-2000s. And Michael made many, many interesting discoveries along the way. He was looking for patterns in the decisions, and he found them. And one of the patterns he found is particularly germane to our work, and that is, it turns out that from the beginning, literally from the first fair use case ever decided in 1841, down to the present day, judges repeatedly have shown a tendency to look for information about what's right, about what's proper, about what's appropriate, to look to custom and practice of the field of activity, of creativity or education, as the case may be, that is in question. And of course, they're more likely to look at it, and they're more likely to be influenced by it if it is well documented. So that's where we, in our very small way, in our project, come in. And Pat's going to talk about it in a moment, despite everything I've said. And your questions reflect this. Questions, your inquiries reflect this. There are still questions. What if I get it wrong? How much trouble am I going to be in? Can I get somebody else into trouble? And it's that or those lingering concerns that we've tried to address in the work that I think Pat is now going to describe.
Thank you. So I want to talk about the process of creating these codes of best practices that have been our way of giving communities of practice some comfort level about the decisions they make, since these decisions around fair use are really decisions about risk, just like all your decisions in the First Amendment area are. You have something to say, and you are paying a great deal of attention to the context of when you say it, so that